Good morning. Welcome to this meeting of the California Privacy Protection Agency Board. It's May 10th, 2024 at 10:41 a.m. My name is Jennifer Urban, and I'm the chairperson of the board. I'm very pleased to be here in person with the board and some members of the public, and to welcome many of you via Zoom as well. And I'd like to thank everyone for your patience while we work out technical kinks with the hybrid meeting. Before we get started with the substance, I have some logistical announcements. I would like everyone to please check that your microphone is muted when you're not speaking, and that's especially important given that we've had to have a workaround for the sound today. For board members and folks who are presenting today, your microphones have a button to turn them on, and you also have to turn them off. So I would like to ask you to be sure to mute your mic when you're not using it. Thank you. And then, very importantly, this meeting is being recorded, so please be aware of that. As it is abundantly obvious, this morning our temporary ability to meet remotely and still comply with that key has expired. Therefore, this meeting is in a hybrid format, and that creates technical complexity. We're also in a new venue today at the California Public Utilities Commission. Accordingly, if we have further technical kinks during the meeting, we will pause the meeting and address the issue. As noted, we have a new venue, our new board meeting location at the California Public Utilities Commission in San Francisco. We really appreciate the CPUC team for their hospitality and not only allowing us to use their auditorium, but also providing the AV assistance today when we've obviously created a challenge. So thank you. That said, this is our first meeting here, so thank you again for your patience. Today's meeting will be run according to the Back-to-Keene Open Meeting Act as required by law. We will proceed by the agenda, which is available on the website and as a handout here in San Francisco. Meetings for the materials for the meeting are also available on our website under meetings and events for this date and here in San Francisco. You may notice board members looking at their laptops, phones, or other devices during the meeting. They are using the devices solely to access board meeting materials. After each agenda item, there will be an opportunity for questions and discussion for board members. I will also ask for public comment on each agenda item. Each speaker will be limited to 3 minutes per agenda item. We also have a designated time on the agenda for general public comment, which is agenda item number 7 today. I'm going to talk now about the lead logistics. If you are attending via Zoom and you wish to speak on an item, please wait until I call for public comments on that item and allow staff to prepare for Zoom public comments. Then use your raise your hand function, which is in the reaction feature at the bottom of your Zoom screen. If you wish to speak on an item and you're doing by phone, please press *9 on your phone to show the moderator you are raising your hand. Our moderator will call your name when it's your turn and request that you unmute yourself to give the comment. Those using the webinar can, of course, use the unmute feature, and those dialing in by phone can press *6 to unmute. When your comment is completed, the moderator will mute you. Please do note that the board will not be able to see you, only to hear your voice. Therefore, it's really helpful if you identify yourself. This is entirely voluntary, and you can input a pseudonym when you log into the meeting if you're joining the webinar as well. If you're attending in person and you wish to speak on an item, please wait for me to call for public comment and then move towards the podium to my left and to your right, where you will be called to speak in turn. As this intended, it's always helpful if you identify yourself, but it is entirely voluntary, and you are free to refer to yourself with a pseudonym or not give a name. Please do speak into the microphone so that everyone participating remotely can hear you and your remarks can be recorded in the meeting record. I'd like to thank Mr. Robert Stanford and his team for managing the technical aspects of today's meeting, including Mr. Francisco Hernandez. And second, I'd like to explain what to do if you attending remotely experience an issue with the remote meeting if it arises, for example, with the audio dropping. If something happens, please email info@cppa.ca.gov. That's India November Foxtrot Oscar Charlie Papa Alpha, Charlie Alpha Golf Oscar Victor, info@cppa.ca.gov. This will be monitored throughout the meeting, and if there's an issue that affects the remote meeting, we will pause to let our technical staff work on the issue. The board welcomes public comment on the agenda item on the agenda, and it is our intent to ask for public comment prior to voting on the agenda item. If for some reason I forget to ask for public comment and you wish to speak on that item, please let us know either by raising your hand here in person or by raising your hand in the virtual meeting, and the moderator will recognize you. If you are in person, so in any case, we will go back and make sure that we get your comment. Once again, please recall that each speaker will be limited to 3 minutes per agenda item for public comments. And if you are speaking on an agenda item, both the board members and the members of the public must contain comments to that agenda item. Relatedly, I'd like to remind everybody of the 7 rules of the road under Badly Key. That is, we have to discuss what we have noticed on the agenda for today, which is why you need to stick to that topic when we have public comment on that agenda item. But as I mentioned earlier, the public can bring up additional topics when the board goes to the agenda item that I've placed on the agenda for that specific purpose. As I mentioned, is number 7 today. When we get there, though, we can listen, but board members cannot respond. We can only discuss whether or not to put that in the agenda for discussion. We'll take breaks today, including lunch for lunch. I'll announce each break in an estimate of how long lunch return to the members of the public and meet with that. Please note that the 9th agenda item for today is a closed session item. When we are finished with the closed session item, we will return and I will announce that it's a closed session so that you know before we go into that session. My thanks to the board members for their service and to all the people working to make it possible today. Again, I would like to supporting us, both the staff of the CPUC and everyone from the CPPA who's working together for us today. I'd like to thank Mr. Phillips Mayer, who's our meeting counsel today, and Josh Connie, who's here in his capacity as our executive director, and all of our expert staff who will be briefing us today. I would like to thank and welcome our new moderator today, Ms. Serena Marcion, and ask her to please conduct the roll call vote. Excuse me, the roll call.
Board Member Lee.
Here.
Board Member Liebert.
Here.
Board Member McTaggart.
Here.
Board Member Worth.
Here.
And Chair Urban. Madam Chair, you have 5 present members and no absences.
Thank you very much, Ms. Marcion. The board has established a quorum. I would like to let everyone know that we will be taking a roll call vote on any action item. With that, we'll move to agenda item number 2, which is an update from the CPPA chairperson. I'm pleased to cover 4 items today, and I'm going to pause for just a second.
Chairperson, may I recommend we go to closed session?
Of course. So there's
And if you could please announce to the Zoom stream that we're going to take the Zoom stream down, and then folks can return to the Zoom stream once it's back up. We'll tweet when it's back up.
Okay, thank you very much. So there is still work going on in the background on the technical issues with the meeting today. So I will announce that we're going to take the closed session items out of order and go ahead and have the board leave the meeting. Let me explain what the closed session item is. And our executive director has asked me to announce to everyone who's joining us by Zoom, welcome, that you should, when we go into closed session, go ahead and leave the Zoom meeting, and there will be a notice on what channel?
Twitter?
On the Twitter channel when the Zoom session is back, and you can just dial back in or log back in at that time. Thank you again, everybody, so much for your patience. So Before we do that, though, I do want to very briefly welcome our new board member, Mr. Drew Liebert, just so people know that you're here and who you are, and we'll be probably when we come back. But for now, please turn your attention in the agenda to agenda item number 9. Agenda item number 9 is a closed session item, closed session discussion of 2 items. First, pursuant to Government Code Section 11126B1 and 2A, we will meet in closed session to confer and receive advice from legal counsel regarding 2 matters: California Chamber of Commerce versus the California Privacy Protection Agency et al. And California Privacy Protection Agency et al. Versus the Superior Court of the State of California for the County of Sacramento and the California Chamber of Commerce. In addition, we will meet in closed session to discuss the personnel matters pursuant to Government Code Section 11126A1. I expect that we will be back within an hour. And again, please do note that staff will be giving a notice when the Zoom session is restarting. Thank you very much for your attention and again for your patience, and we will return after the closed session item. Thank you.
Thank you very much, Mr. Sultani, and welcome back everyone to this meeting of the California Privacy Protection Agency Board. Thank you all for your patience while staff continue to work on the technical difficulties with our hybrid meeting while the board met in closed session. We are returning now from closed session, which was agenda item number 9 on your agenda for today, and we'll be going to agenda item number 2, which is the chairperson's update. I'm pleased to cover 4 items today. The first is bittersweet. Many thanks to Ms. Lydia De La Torre for her stalwart service on the board from the inception of the board and the agency. She's lent us her passion for privacy, her transatlantic expertise, and has made tremendous strides towards building our connections across the data protection and privacy regulatory community. For example, she was key to our joining the Global Assembly 2 or 3 years ago. We have a more formal thank you planned for Ms. De La Torre in July when we hope to welcome her in person. So we must say goodbye to Ms. De La Torre, which is bittersweet. At the same time, I'm absolutely thrilled to welcome Mr. Drew Liebert, who is tasked with filling her big shoes as the appointee for Senate President Pro Tem Mike McGuire. Mr. Liebert took his position in April of 2022, so this is his first time that he's joining us for a board meeting. He brings exceptional California policy experience to the board, and specifically California legislative experience, having served for more than 2 decades in staff leadership roles in the California legislature, including 18 years as chief counsel to the Assembly Judiciary Committee. Judiciary considers many technology measures, so he has tremendous experience considering those measures, evaluating those, analyzing them, and advising state lawmakers on tech issues. And most recently, he served as Chief of Staff to the Senate Majority Leader. He was a Coro Foundation Fellow in Public Affairs. It's an amazing program. And we're pleased that we'll have that experience on the board as well. And he's been named a California Lawyer of the Year. Nearest and dearest to my heart, he's a graduate, a 2-time graduate, I believe, of UC Berkeley, a recipient of a master's in public policy from the Claremont Graduate School, and his law degree is from UC Berkeley School of Law. Welcome, a warm welcome to you, Mr. Liebert. We are delighted to have you. And I will ask the board for comments in a moment, but I want to go ahead and get through my 4 items. My third is that I'm absolutely delighted to highlight the pre-rulemaking stakeholder sessions the agency is holding to provide information on and hear from the public on the draft automated decision-making risk assessment and cybersecurity audit cybersecurity audit regulations that the agency is working on. They start next week, and I'm really excited. There will be a first one in Los Angeles this coming Monday, May 13th. The second one is in Fresno on Wednesday, May 15th, and the third is in Sacramento on Wednesday, May 22nd. The first two sessions are in person, and the Sacramento session will be hybrid with both in-person and remote options. We won't be discussing those drafts today. They're under construction, and staff is receiving input as in the sessions. So they're not on the agenda for today's meeting, but the board had a robust discussion of them in March, in which members of the public and some members of the board requested these pre-rulemaking public sessions. I know I was especially strong in my request for public input, and I want to deeply and truly thank the staff for putting these together and in such a short period of time. I know this has required a very large team, a large chunk of our small but mighty agency working full tilt, to be sure to bring the public even further into the conversation and collect the information. So I'm really looking forward to doing the welcome in Fresno and Sacramento, welcoming people there. And again, I really, really want to thank the staff for this and look forward to hearing from the public. This is an appropriate segue into my fourth update item, which is the day of the finale of National Public Service Recognition Week, which is an annual week for honoring those in public service. I'd like to especially recognize the staff at the agency for what they've been able to accomplish over the last year and indeed the last years with a tiny team to a lean team. They have put out regulations. They've developed some amazing public awareness materials and guidance for companies. They have built an enforcement team, and they have been doing all of the things that make an agency run, but that are invisible as well. And I really want to recognize them, especially for taking a chance on a new agency and bringing all of your expertise and energy and passion to serve the public, to protect Californians' privacy. As we continue to move through the technological age, we see you, we appreciate you, and we are incredibly impressed with what you've accomplished and your dedication every day to protecting Californians' privacy. So thank you from me, and I know I speak for the board as well when I say that. Those are my 4 items for today, quite celebratory and a little bittersweet. Are there any questions or comments from other board members? And remember, I have to turn to see you, so give me a chance. Yes, Mr. McTaggart? And then
Yeah, I'd like to welcome Drew, Mr. Liebert. I just want to say he was someone I worked with closely in the legislature over the years. And so from my perspective, his commitment to privacy is well established. And he was always a pleasure to work with in that role, wearing that hat. And I'm looking forward to working with him wearing this hat, because I know he's a thoughtful person who is focused on getting things done as opposed to posturing.
thank you, Mr. McTaggart. Other questions or comments from board members? Wonderful. Do we have any comments from the public?
I believe there's a hand raised online.
Thank you.
Erica Del Val, you have 3 minutes. Please unmute yourself. I believe Erica, you can go ahead. Erica, we're not hearing you, so we can give you just a moment longer. Chair, we don't have any other comments. Would you like me to?
Thank you, Ms. Marzian. I just want to pause and ask if there could be an issue with the audio the other way. And if we can always, I will invite our commenter to come back around during the open session for sure, the item for open public comment. But also I would just ask, please stop me if we need to pause the meeting. Otherwise I'll move on.
We just had another hand raised.
Okay, wonderful. Thank you.
Andrea, go ahead and unmute yourself.
I'm not quite sure the relevance of this particular question according to the agenda item, but with that being said, do you have to basically state your disability in order to receive ADA rights when it comes to in accordance to this meeting or any other public meeting? And I have that question because I do have a senior that would like to attend, but they're not quite sure on what they should do if they should um, be present during a meeting because they cannot use that whole virtual world that you speak of.
Thank you very much. Mr. Laird?
Would you like me to respond? So for those wishing to participate in person, we do post our agenda out at least 10 days in advance on our website. And it also has information about if you require accommodations for a disability, who to contact so we can arrange for those proper accommodations. So I'd encourage folks to both visit our website, and then you can also email our info box, which is info, I-N-F-O, @cppa.ca.gov.
Thank you so much, Andrea McPherson. And please do contact staff if you're having trouble with the instructions in the agenda. Thank you so much. Ms. Marzian, is there?
Yes, we have one more hand raised.
Thank you.
SYASL intern. Go ahead and unmute yourself.
Hi, I'm currently just in as an attendee, but I was curious to know which item number we are, like in reference to the agenda.
Of course, absolutely. We are on item number 2, and we will next move to item number 3, which is an update from our Deputy Director for Legislation.
Thank you.
Madam Chair, we have no other hands raised.
Thank you very much, Ms. Marzian. With that, we will move to agenda item number 3, which is an update from our deputy, a legislative update and authorization of CPPA position on pending legislation from our Deputy Director of Policy and Legislation, Ms. Maureen Mahoney. As a reminder, this item is part of our regularized calendar, which you can find on our website under the meetings and events page. So far as possible, we have to move things around sometimes. And this is scheduled to, as much as possible, help coincide with the legislative calendar such that we can provide guidance at a helpful time for the legislature. Also, as a reminder, this is one of 2 meetings, regularized meetings on legislative matters. The other is the last meeting of the year and would normally include discussion of any potential CPPA-sponsored bills for the next legislative session. Also, as a reminder, and as background for Mr. Liebert and Mr. Worth, whom I think this is their first legislative meeting, in December 2022, the board adopted a policy for considering bills that are intended to align our legislation intended to align our legislation and policy teams and our resources work with the work we are charged for the public. Accordingly, Ms. Mahoney briefs us on bills related to the agency. In practice, this means those that would affect the agency's operations or jurisdiction. And in addition, board members or staff are always free to bring bills of interest to her attention for her review. So I'd like to draw your attention to the materials for this item. There's a memo on AB 1949 and a presentation, if I may say so, Ms. Mahoney. It's very helpful indeed. It's an active time in the legislature for work that connects to our work. And so there are a number of bills, and it's very helpful to have this resource. And with that, I would like you to turn it over to you. Please go ahead.
Thank you, Chairperson Urban. Board members, really appreciate the opportunity to discuss the agency's legislative work. And we can go ahead and move to the next slide, please. For this item, I'll do several things. First, provide an update on federal legislation, specifically the newly proposed American Privacy Rights Act discussion draft. Next, I'll provide a brief update on the states that have adopted consumer privacy legislation this year. Third, provide an update on California bills that in staff's view would affect the agency. And at the end, I'll present for board consideration a recommended position on a bill that in staff's view would have the greatest impact on the agency, AB 1949, which seeks to amend the provisions in the CCPA with respect to children. And then perhaps after each of these sections, I'll pause for comments or feedback from the board, recognizing that we're going to be covering a lot of territory in this item. Next slide, please. First, turning to federal legislation. So as you've likely heard, Congress has reached two corners agreement on a privacy framework with sweeping state preemption language. Chair of House Energy and Commerce, Kathy McMorris Rogers, and Senate Commerce Chair Maria Cantwell announced agreement on an American Privacy Rights Act discussion draft in early April. In terms of where the other two corners stand, House E&C Ranking Member Pallone seems tentatively positive. Senate Commerce Ranking Member Ted Cruz has criticized the bill, expressing concerns, for example, over the Federal Trade Commission's role in the bill. To provide some context, preemption and the private right of action have long been sticking points for a federal privacy law. Approximately 2 years ago, there was three corners agreement on a bill called the American Data Privacy Protection Act, or ADPPA. At that point, it was Chair Cantwell who didn't endorse that proposal, and the bill included sweeping state preemption and a weak private right of action. APRA is quite similar. Our agency opposed the ADPPA 2 years ago, and the governor, attorney general, and the California legislature weighed in with their concerns about preemption as well. Ultimately, ADPPA advanced out of House E&C in 2022. It didn't make it to the House floor. Then Speaker Pelosi expressed her concerns about preemption in the bill. Of course, the political landscape has changed significantly since then. In terms of where APRA sits now, it's still a discussion draft. However, Congress seems to be moving quickly. House E&C has already held a hearing last month on the bill. Markup is expected later this May, where it will likely advance out of E&C. I expect that Senate Commerce will want to move quickly as well. Simultaneously, we're keeping an eye on legislation with respect to children's privacy, which could move as well. There's a lot of discussion over COPA 2.0 and COSA, which were filed as amendments to the FAA Reauthorization Act. That doesn't appear to be happening, but I wouldn't be surprised to see votes on those bills given the support in Congress for them. Staff is extremely concerned about the APRA. CPPA staff sent a letter to House E&C and Senate Commerce outlining our concerns. The governor, the AG, and the California legislature sent a letter as well. And the California Attorney General recently led a 15 AG letter highlighting their concerns with preemption. In terms of why we're concerned, the draft seeks to preempt nearly every provision in the California Consumer Privacy Act and the California Delete Act. There are carve-outs in preemption in certain narrow areas, for example, employee privacy, but the bill would have a huge impact on California privacy law. Because of this preemption language, the bill seeks to remove existing protections from California consumers. This includes the ability of the agency to issue regulations to implement most provisions of the California Consumer Privacy Act and to enforce the California Consumer Privacy Act, the unique floor on protections established by Proposition 24, whereby amendments to the law must be in furtherance of the law's intent to protect privacy, the ability of the California legislature and the people of California through ballot initiative to advance new privacy legislation to protect Californians, the global data broker deletion mechanism, which was added to California law through the Delete Act. APRA proposes to replace that with a global data broker do not collect option, which would still allow businesses to use and sell previously collected data. And lastly, removing sexual orientation, immigration citizenship status, and union membership from the definition of sensitive personal information, among other protections. Next slide, please. Unless the language with respect to the state significantly improves when the bill is formally introduced, staff plans to use its existing delegation to oppose the bill on behalf of CPPA. So just to explain the delegation in more detail, in July 2022, the board voted unanimously to first oppose as currently drafted the ADPPA because it sought to significantly weaken California's privacy protections by preempting the California Consumer Privacy Act and other state privacy laws. Second, the board voted to oppose any bill that in staff's view similarly threatens crucial privacy protections for Californians. And by a third motion, voted to support federal privacy legislation that in staff's view sets a true floor and allows states to implement stronger protections. So that has provided very helpful guidance for staff. And that's the current state of play with from staff's point of view. I'll pause here for any comments or feedback from the board.
Thank you very much, Ms. Mahoney. Comments or thoughts from the board? Yes, Mr. McTaggart?
I had not had a chance to delve into the APRA in any great detail at the last meeting, but now I have, and I'm even more happy that we are opposing it because it's very well written. There are a couple of loopholes from an industry point of view that I think would significantly weaken the existing standards that we have here in California. And it was disappointing for me because the first time you read it, you think, oh, that sounds pretty good. But after you kind of iterate through some of the exceptions there, so I'm going to be, sending a memo out at some point here to some people in DC. But it's once again, it's sort of the wolf in sheep's clothing here. So I was sad to see that, and I continue to think that we have much stronger protections for Californians than this would offer.
Thank you, Mr. McTaggart, Mr. Werther, Mr. Liebert. I fully agree with Mr. McTaggart. Thank you, Ms. Mahoney, for following the bill. I very much appreciate Congress's efforts to protect all Americans' privacy. I think the agency would like for Americans generally to have some of the strong or all of the strong privacy protections that we have in California. I in no way want to undermine efforts to protect Americans' privacy, but California voters, 9.4 million of them, if I got that right, Mr. McTaggart, 9.4 million Californians voted for strong privacy protections, and they voted for a floor under those protections to keep them in place and to keep them strong. They can be built on, but they cannot be diminished or not diminished easily. And that is crucially important. 9.4 million Californians voted for a floor on protections. Congress should do the same. They should not preempt state bills that build on top of the protections Congress puts in place. Americans should have a strong floor of protections, and states should be able to build on top of them. 9.4 million Californians also voted to establish an independent watchdog to look out for their rights. That's the California Privacy Protection Agency. And so again, while I greatly respect what the members in Congress are doing to work towards protections for privacy for all Californians, this watchdog cannot allow, or at least cannot support, a bill that would undermine the protections for Californians. So I absolutely agree. I'm glad that we have given staff the authority to continue to oppose if the bill has these flaws, and I look forward to hopefully Congress improving it so that we can support it. So thank you very much, Ms. Mahoney. Any other comments? All right.
Okay, next slide, please. And I'll just go ahead while that's setting up. But the rest of the presentation will illustrate the importance of supporting states' ability to legislate, since there is a great deal of activity in this area. With respect to multi-state privacy laws, things have been very active, so active that this slide deck went up a couple days ago. It's already outdated. And actually, while you were in closed session, the Minnesota legislature passed a privacy law. So we'll just have to forget about all the numbers. Let's see.
Well, what do we have to follow Bagley-Keene. So we'd have to agendize the new bill right, to the next meeting.
Yeah, so when I provided my last update in December, approximately 13 states had comprehensive privacy laws. Now, I think 18 do, depending on how you count. This includes Florida. Some don't include Florida. Maryland was signed just this week. That's a comprehensive bill that has data minimization similar to the CPPA's regulations in Section 7002. So that was a positive development. Now, by my count, I think 11 states, including California, have a browser privacy signal requirement. That's a really important part of making privacy law workable for consumers. 5 states adopted privacy laws in 2024, and we expect this activity to continue, and staff will continue to engage by providing technical assistance and sharing our framework. There's also a lot of legislative interest in ADMT and AI. Staff participated in a multi-state working group to hear about other states' approaches to these topics. Colorado recently made news. Their legislature advanced SB 205, which is now under consideration by the governor, which would provide a framework for regulating AI and ADMT, focus on preventing algorithmic discrimination, creating new obligations for risk assessments and disclosures. And staff will continue to encourage consistency in these areas as well. Okay, moving on to the next slide, please. So moving on to California. So to give you a sense of where we are in the legislative calendar, which I typically do, here's some upcoming key dates. We're rapidly approaching the deadline for bills to pass out of the House in which they were introduced. That's May 24th. The budget bill has to be passed by June 15th. By July 3rd, policy committees have to pass bills. Bills have to be out of the legislature by August 31st. The governor has until September 30th to sign or veto. If he takes no action, they take effect. And then bills go into effect January 1st, 2025, unless otherwise stated. Next slide, please. And next, I'll provide updates on several pieces of California legislation that would affect the agency. The first is AB 3048, which you're familiar with because of the December meeting. Consistent with the process for adopting legislative proposals, the board approved a proposal to require browsers to offer to consumers the ability to enable opt-out preference signals, and requested staff updates on the bill. Assemblymember Lowenthal introduced this legislation in February. It's AB 3048. Briefly, as you know, businesses receiving these signals are required to honor them as an opt-out of sale and sharing, but many of the biggest browsers like Google Chrome, Apple Safari, Microsoft Edge don't offer native support for these signals. So this bill would address that, providing significant benefits not only for consumers in California, but those in other states where there are browser privacy signal requirements to make it easier to exercise their rights. So the bill has advanced out of Assembly privacy, it's advanced out of Assembly appropriations. It now awaits a floor vote. So it would have to get out of the Assembly by May 24th and then cross over to the Senate for consideration there. And I'll pause here in case there's anything the board would like to share.
Thank you, Ms. Mahoney. Yes, Mr. Liebert.
I'm very excited about the bill and that your work on it. I appreciate it. I think it's a great opportunity for the agency to really lead the way on what we mean by making it easy for consumers to express their desire in this regard. And so I want to make sure that the language of the bill, if you'll focus on that, it talks about the agency adopting regulations, including to update the definitions of browser and device. I think it should say including but not limited to, because I think that it will be and should be up to us to determine by regulation what do we mean by easy to locate and use for consumers. I think that's really important. A lot of times these browsers can make it kind of difficult to express your wishes, and so we have to make sure that we focus on that issue. So I'd like to encourage you to think about that.
Great, thank you.
Thank you.
Thank you, Mr. Liebert. Other comments or questions? Wonderful. Thank you, Mr. Mahoney. Thank you, Ms. Thank you, Mr. Liebert, for that helpful comment. And thank you, Ms. Mahoney, for continuing to help shepherd the bill through and support it in the legislature. I think we're ready for what's next.
Great. And then moving on to the next slide. Next is AB 3286, which is an omnibus bill from Assembly Privacy. It includes several fixes to the CCPA proposed by agency staff. This is all very technical. I will do my best, but so it would do three main things: clarifying in the CCPA first the method for calculating the consumer price index, adjustments to monetary thresholds, so that these adjustments can be self-executing and not require a rulemaking. So currently there are 5 thresholds in the CCPA. The monetary threshold for businesses covered, so that 25 million number, damages pursuant to a civil action in the event of a negligent data breach, administrative enforcement fines, civil penalties, and of course the CPPA board member per diem. So they're currently required under law to be adjusted by CPI in January of every odd numbered year by rulemaking. This would put it right into the statute and make it self-executing. Second, to clarify in the CCPA that when responding to sworn complaints, the agency does so with its existing law enforcement privileges. So as you know, the CCPA gives the agency the authority to investigate businesses for potential violations on the basis of a sworn complaint. In its current form, the statute states that the agency must notify consumers about the action together with the reasons we've taken that plan. The reasons for the action or non-action. But when we do so, we're subject to existing law enforcement exemptions and privileges. So this just clarifies in the statute that situation to reduce the risk of confusion for consumers. And then third, it clarifies that the agency begins administering the grant program when the amount of grant funds available after all of their distributions have been made exceeds 300,000. So to provide more context on that, the agency is tasked with distributing every year via grants 9% of the funds that remain in the Consumer Privacy Fund after it's been used to offset costs. And by initiating the grant requirement when the amount of grant funds available exceeds 300,000, that ensures that the agency will be tasked with distributing these funds at the point at which the amount of funds justifies the administrative costs of overseeing a grant program. So this bill advanced out of Assembly Privacy and Appropriations. It faces no opposition, and the next step would be to advance out of the Assembly. Next slide, please.
If I may, Ms. Mahoney, I've recognized that Mr. Lay has joined us by video conference. And so under Bagley-Keene, I just request that Mr. Lay go ahead and declare for the room anybody he's with in the room that's 18 years or older in his relationship to them.
Yes, I'm at the airport. There are many people 18 and over, but there is no relationship, so nothing to declare.
Great, thank you.
So next we have 2 privacy bills that propose to amend the CCPA. First would be AB 1824 from Assemblymember Valencia. That would clarify that when a consumer has opt out the sale or sharing of their personal information at a company, if that company is acquired by another or merges with another, that request transfers over to that new situation. I don't believe it has any opposition. It's just crossed over to the Senate. The second, SB 1223 from Senator Becker, and that would essentially amend the CCPA's definition of sensitive personal information to include neural data. And that would reflect legislation that was recently adopted in Colorado. That bill introduced in the Senate is being considered in Senate appropriations. And staff will continue to monitor those bills.
Ms. Mahoney, Mr. Worth, have a question or a comment?
Yeah, no, a question on 1223. I read it 3 times. I just want to make sure I understand exactly what, like, can you give me an example of how this will come into effect?
Sure. So my understanding is that this is very kind of forward-seeking, forward-looking. But the idea is we may get to the point where you could have devices that could be controlled through thought, like really hands-free devices, raising questions about the data that's being collected, about our thoughts, our emotions, our senses. So clarifying that has additional protections.
So we kind of feel the need to get so far ahead of it for something that doesn't exist yet, and we want to, or is that what was behind this bill getting drafted and getting to the place it is? Was it our direction?
No. So I think this is lawmakers looking to Colorado, which recently adopted a similar law, and trying to make sure that protections in California are up to that level. So I'm just providing an update on this bill that seeks to amend the CCPA, but we're not involved in it.
Okay. And I guess if it's misguided, we learn more about what we're aiming at. We can amend it later, or introduce new legislation later to adjust this.
If there are concerns about uh, that legislation, that may be something that, staff could express to lawmakers.
Okay. Thank you.
I will say adding neural data to sensitive personal information seems pretty low risk endeavor to me. There is experimental work for people with disabilities to be able to do things like control a computer. So it's in the future. I don't know how far in the future it is. I really appreciate Mr. Worth's comment. It is always a good idea to make sure that legislation isn't getting so far ahead that it is defining technology that doesn't exist yet, for example. So thank you for keeping an eye on it. But I think in the event that this is something that can happen at a wide scale, like it's definitely sensitive information. So any other comments or questions at this moment? All right, thank you, Ms. Mahoney.
Great. So next slide, please. Great. And then we'll continue. So these are more updates on bills that we're not involved with, but they've been introduced in the legislature. They would affect the CCPA. So both of these next two are intended to increase protections with respect to the use of personal information to train artificial intelligence. So the first is AB 2877 from Assemblymember Bauer Kahan. And that would amend the CCPA to prohibit a developer from using kids' personal information to train AI without permission. That's just advanced out of Assembly appropriations. The next step is the Assembly floor. And next slide, please. Actually, please go back one. And the second is AB 3204, also from Assemblymember Bauer Kahan. Data Digesters Registration Act, and that one's similar to the Data Broker Registry. There is delayed implementation, so by January 31st, 2026, data digesters, which are roughly defined as entities that use personal information to train AI, would be required to register with our agency, pay a registration fee, and provide certain information. And then we'd be tasked with creating a page on our website to provide that information to the public. So it doesn't amend the CCPA, similar to the Data Broker Registry. It's done in a different part of the code, but it would provide us with rulemaking and enforcement authority. So that bill is currently in Assembly appropriations. As we know from the Data Broker Registry, this will require resources. We've provided a fiscal estimate to Assembly appropriations. We do expect registration fees would offset costs, but we are keeping an eye on that one because it would require resources for the agency. Next slide, please. And then the third bill from Assemblymember Bauer Kahan, AB 2930. So this bill would not amend the CCPA, but as you can see, there's a lot of overlap with the agency's draft AD&T regulations. So I won't get into all the provisions of the bill, but at a high level, it would require deployers of automated decision tools to refrain from using these tools, resulting in algorithmic discrimination, would require impact assessments, notice to consumers, and if feasible, deployers would have to accommodate a request not to be subject to these tools. So again, a lot of overlap between this bill and the draft AD&T and risk assessment regulations with which the agency is proposed pursuant to its statutory requirement under the CCPA. Specific areas of overlap would be, pre-use notice, risk assessments, and some form of opt-out with respect to AD&T. There are differences, and this bill would apply to a broader set of entities. It applies to government entities, nonprofits. It has a lower threshold for businesses, and there's this, prohibition on algorithmic discrimination that goes a bit farther than the draft regs. Since the bill doesn't propose to amend the CCPA, It wouldn't directly impact the agency's workload. Enforcement would be handled by the Civil Rights Department within the administration, AG, district attorneys, and other officials. Because creating two different ADMT frameworks for businesses that would fall under both requirements could make compliance difficult, staff suggests continuing to work with the author to try to ensure consistency between the two frameworks where possible. Ms. Gillet?
Yeah, I just wanted to note that, as far as I know, the draft regulations doesn't have as specific of a focus on algorithmic discrimination as AB 2930. So, I do think there are differences between the two risk assessments. In a company, when they're doing a CPPA risk assessment, looking at risks, benefits, and safeguards, they would essentially be remiss not to be testing for algorithmic bias. So this kind of fills a gap that may potentially exist in the CPPA's draft regulation.
Thank you, Mr. Lay. And then moving on to the last bill, AB 1949. And this bill is sponsored by the Department of Justice. It proposes to amend the CCPA to remove the actual knowledge standard for determining who is a child. It provides opt-in protections to kids up to 18 rather than under 16 under current law. It expands opt-in protections. Currently that applies to sale and sharing, but this would extend it to collection, use, disclosure, as well as sale and sharing. And then it requires the agency by July 1st, 2025 to promulgate regulations outlining technical specifications for an opt-out preference signal that could indicate that the consumer is a child. And then by that same timeline to adopt regulations regarding age verification. So staff released a memo on this. We recommended that the board consider taking a supportive amended position on this legislation. Staff very much appreciates the intent of the bill to protect children online, but has concerns about removing the actual knowledge standard and how that could be counterproductive by incentivizing increased data collection to determine who is a child. Staff's also concerned that the new rulemaking language on age verification and the opt-out preference signal with the aggressive deadline could unduly burden the agency at this time. So staff has suggested a balanced approach, suggesting amendments to outline in statute a constructive knowledge standard inspired by the newly adopted law in Maryland, specifically a known or should have known standard, but also builds on that by identifying suggested factors to determine whether a business should have known that the consumer is under 18. That would obviate the need for required rulemaking because it would be providing guidance in statute. And again, the goal is to balance the AG's request for a higher standard of verification while mitigating privacy concerns as well as the burden on the agency. And then it would also enable enforcement right away rather than waiting for regulations. This concludes my presentation. I'm happy to answer any questions. Thank you, Ms. Mahoney. Mr. Worth, yes, please go ahead. And then I have a queue. Mr. Worth.
Great. On 1949, Ms. Mahoney, question, the language on this should have known comes straight from the Maryland. So how long has that been in effect?
Oh, that was just adopted. So it's known or should have known. Where this proposal develops on that is by outlining suggested factors to provide a bit more clarity. I'm not an attorney, but I do understand that the should have known standard is common in existing law, and there's a fair amount of case law behind it.
Okay, so thanks.
Mr. Liebert.
Have you had a chance to talk with the author about the actual knowledge concerns that we have about that? And have they been resistant to this point, or where does that stand?
Yes. So we've shared these suggested amendments with the author and the sponsor. They're very engaged on this issue, very willing to discuss. But, I do emphasize that this is purely a CPPA staff proposal, not something that they've signed off on in any way.
Yeah, so I think I share the benefits of the new or should have known, which really comes out of tort law. I believe. And I think that makes a lot of sense. You can talk about constructive knowledge, those different types of standards to acknowledge that there are different ways to do this. I'm a little skeptical in the analysis about being too sensitive to encouraging the over scooping up of data, because I think they're doing a very fine job, these companies, in scooping up extraordinary amounts of data already, much of which will already be able to signal to them that they're probably dealing with kids or underage people. So I don't know that we should be overly sensitive to that concern that the opponents, interestingly enough, who are the scoopers many times, raise. So I do think it's good to explore those avenues as to the constructive knowledge or knew or should have known. So thanks for that.
Thank you, Mr. Liebert. Mr. McTaggart?
Yeah, I'm troubled by the. Yeah, I understand the intentions of the bill. I think are very good, and no one would disagree that protecting children's privacy is not a laudable goal. What I'm troubled by, and have been ever since this in a different iteration came up on the age-appropriate design code, is the notion that this will really require age gating, which for those of people who are not familiar with the term, really would be require entities to really say, type in your age, and we're going to collect more information. And I've got the injunction up here in front of me from the age-appropriate design code, which says where the judgment, where the ruling says, a lawyer here, the materials before the court indicate that the steps a business would need to take to sufficiently estimate the age of a child would likely prevent both children and adults from accessing certain content. And then it goes on to say, age estimation and privacy provisions thus appear likely to impede the availability and use of information and accordingly regulate speech. And this is one of the reasons that the age-appropriate design code was the injunction was instituted. And so I guess I'm actually pleased to have my new colleague here, because I really think this is a well-intentioned but misguided step, and I like that notion of having this new standard of known or should have known. And so I noticed that there's some privacy groups, some very leading privacy groups, Privacy Rights Clearinghouse, EFF, that oppose the bill. There are some Open Privacy that oppose unless amended, and then there's some ACLU that support if amended. And I just wouldn't mind getting your take on the distinction between oppose unless amended and support if amended. They're two separate things, but I'm on the more opposed unless amended, but I don't know if it makes any real substantial difference.
Ms. Mahoney?
I think, the support if amended position, recognizes the good intentions behind the bill and the willingness to find a path forward with suggested amendments, as we've done in the memo. So I think, we appreciate the legislature's concern about these issues. And I know that the AG, who's a good partner of ours, is very concerned about these issues as well as the governor's office. So, I want to make sure that we're, working with all these partners to help address their concerns so we can find a path forward.
Thank you, Ms. Mahoney. I will say, and I'll ask Ms. Mahoney and Mr. Liebert to weigh in if I got this wrong. The way I see the question before the board with regards to support if amended or oppose unless amended, is that we are giving a sense to the staff of whether we support the basic goals of the bill, first of all, and secondly, if we're comfortable with the proposed framework that Ms. Mahoney has set out for us, for her to go forward, and that we would be comfortable with the bill if those changes were made. Whereas oppose unless amended would mean that the default, of course, is that we oppose it, and then it's a little bit, I think, less clear how easy it would be to change that position. Did I get that even basically right, Mr. Lee?
Absolutely. I would say that it's really just an art form, whether you say support if amended or support unless amended. So unless versus if is not so big. It's in the eyes of the beholder.
matters in contracts, but maybe.
Yes, not contracts, but in legislative ease. Yeah, I absolutely do think we should support in concept, and in that case, the support, if amended, gets that across that we're not quite over the finish line for the kinds of concerns that you've raised there, but that we really want to work and get to that location. So supportive of what the staff is suggesting there.
Thank you, Mr. Liebert. And I really do. I want to commend Assemblymember Wicks and the Office of the Attorney General, DOJ, for working so hard on this issue because it is incredibly important and it is a bit of a conundrum. It's a little bit counterintuitive, the idea that having an actual knowledge standard could actually reduce kids' privacy and also reduce their ability to access information that they need privately. But technically speaking, and in practice and in the world, that can be the case. And so I think, I certainly share the sentiments that I've heard from my fellow board members that we really would like to help get this right. And so I really appreciate the thought that's gone into the recommendation today. Other comments or questions? Mr. Lay, I just want to give you a chance in case I missed your hand.
No comments.
Okay, thank you, Mr. Lay. Other comments and questions? All right. In that case, I would like to highlight that I plan to request a motion to accede to Ms. Mahoney's recommendation, which would be a motion to support AB 1949 as amended according to the Ledge staff's analysis. So support if amended to maintain the actual knowledge standard, or actually, you know what? I apologize. I have a question, which was I was listening carefully and I forgot my question. In your really wonderful, comprehensive, and thoughtful memo, you did mention the positions of different groups that Mr. Liebert and Mr. McTaggart mentioned, and I was wondering about the support if amended positions. Are the amendments suggested by those groups similar to these? Do you know?
For the supportive amended position taken by the ACLU, for example, one of their requests would be to maintain the actual knowledge standard.
Okay. Mm-hmm. All right. Thank you. So for everybody's edification, I will, before we take public comment, so everybody knows what's on the table, I plan to request a motion to support AB 1949 if amended, to either maintain the actual knowledge standard or establish in statute an alternative standard. For example, that the business knew or should have known that the consumer is less than 18 years of age, to identify factors suggesting the consumer is a child, such as the nature of the product or service offered by business and the consumer demographic, to emphasize that these provisions do not relieve businesses of their data minimization responsibilities, to remove the duplicative requirement that the agency issue regulations to establish technical specifications for an opt-out preference signal that allows the consumer or the consumer's parent or guardian to indicate the consumer is a child, to remove the requirement for the agency to complete an age verification rulemaking by July 1st, 2025, or at the least to extend the deadline to July 1st, 2026 or later, and to authorize staff to continue to support this bill, even if amended, if in staff's discretion, the amendments are consistent with the objectives laid out in the staff's analysis and the board's discussion today, and to authorize staff to remove support for or oppose the bill in staff's discretion if it is no longer consistent with these objectives. So I may try to clean that up a little bit while we're also listening to public comment, but that is the general framework that I will propose. Thank you, everybody. And with that, I would like to ask if there is any public comment of Ms. Marisol.
This is for agenda item number 3, legislative update. If you'd like to make a comment at this time, please raise your hand using the raised hand feature or by pressing *9 if you're joining us by phone. Again, this is for agenda item number 3. Madam Chair, I'm not seeing any hands raised at this time.
Thank you very much, Ms. Marzian. With that, I request a motion to authorize agency staff to support AB 1949 if amended to maintain the actual knowledge standard or establish in the statute an alternative standard. For example, that the business knew or should have known that the consumer is less than 18 years of age, to identify in the statute factors suggesting the consumer is a child, to emphasize that these provisions do not relieve businesses of their data minimization responsibilities, to remove the duplicative requirement that the agency issue regulations to establish technical specifications for an opt-out that relate to whether or not a consumer is a child, and to remove the requirement that the agency complete an age verification rulemaking by July 1st, 2025, or to extend the deadline to July 1st, 2026 or later, and to authorize staff to continue to support this bill if amended, even if amended, if in the staff's discretion, the amendments are consistent with the objectives set out in the memo before us today and our discussion today, and to authorize staff to remove support for or oppose the bill if amended, if in staff's discretion, it is no longer consistent with the objectives set out in the materials for today or our discussion for today. May I have such a motion?
I have a question first,
Yes, of course.
and this is for the group and for staff. I'm just focused more on the should have known. I liked your explanation of the difference between actual, because I would wake up this morning thinking actual is the standard you want to strive for. But now we're moving the age from 16 to 18, right?
Mm-hmm.
One of the factors is the nature of the product that's being sold. It just seems like that's a real gray area when you're talking now about 18. So I just don't know how to get comfortable with that. Maybe someone can help me, but I just want to make sure we're not creating a problem that's not easily solved for those that are bound by this. That makes sense?
That does make perfect sense. Thank you, Mr. Worth. Yes, I think Ms. Mahoney, tell me if I'm wrong, but that is generally sort of the way the federal COPPA works. But of course, COPPA is thinking about children under 13. So you've got cartoons and you've got fuzzy characters and you've got things that are possibly a little bit more obvious than for a person who's on the cusp of being able to be drafted, for example. Yeah. Mr. McTaggart.
Thank you, Board Member Worth, because that's a really excellent point. And we ran into that during the drafting. And you have a whole set of other groups that will now come out against you. Oftentimes people exploring their sexuality or reproductive services, and they're 17 years old, and they feel like an adult and they don't want to all of a sudden be treated like a child here. So maybe we could amend the recommendation and include one more bullet point, which would, for the sake of argument, be something like an urge staff to work with the author to distinguish special treatment for children between 16 and 18 who may need to be treated like adults. And that's terrible language, but something along the line to distinguish the fact that a 13-year-old is a long way from a 17-and-a-half-year-old. Great point, Jeff.
Thank you, Mr. McTaggart. Other comments or questions?
I just wanted to reassure my colleague that the good thing I think
Use your
about the bill
microphone.
is that we are. I think I'm on. Yeah. Is that if I understand this correctly, the bill is proposing to expand protections for the sale or sharing of their personal information. So this is one area, whether it's 17 or 18, if you don't get it quite right, if there's a bit too much, I think, of conservativeness in that regard on a consent issue, that's probably a little bit less scary, if you will, than some of the other issues that groups care about in terms of how they're being treated as adults, right? So, but I think that's a great addition to it. Yeah,
It's expanding.
Yep. I think that's a good addition to have further discussion about that.
Okay, great. Thank you. I just need to think about it a little bit because I'm trying to figure out how to.
I would want to ask you to repeat the entire motion. So I apologize if that's where you're headed.
Yeah. No, you all are
Just
you all
amend it.
making me work really hard today. Okay, so I would like to propose a motion of the form that so here's let me back up. Mr. Laird is going to have to bless this, this form of motion or not. So you will tell me if this works or not. I'd like to propose a motion of the form of the motion that I set forth before public comment with the amendment that staff is urged to work with the legislature when identifying factors suggesting that a consumer is a child, that recognizes that there is a range of ages and a range of sensitivities involved in age verification for children of different ages. Yeah. That works, Mr. Laird?
That's
Okay,
acceptable.
may I have such a motion?
So moved.
Thank you, Mr. McTaggart. May I have a second?
Yep.
Thank you, Mr. Worth. I have a motion on the table and a second. Ms. Marzian, would you please conduct the roll call vote?
Board Member Lay,
Aye.
Board Member Liebert,
Aye.
Board Member McTaggart, Board Member Worth,
Aye.
Chair Urban.
Aye.
You have 5 ayes.
Thank you, Ms. Marzian. The motion carries with a vote of 5-0. I want to really thank Ms. Mahoney for this very helpful legislative update, for the legislature and all the sponsors for working on these important bills, and to the board for the very thoughtful discussion. I hope that we were also helpful to you today, Ms. Mahoney. Thank you very much. With that, we will move to agenda item number 4, which is an update regarding SB 362 implementation, including discussion and possible action on proposed data broker registration regulations. As a reminder, for those of us, including myself, who are not as facile with all the bill numbers as Ms. Mahoney, SB 362 was passed by the legislature and signed by the governor last year. It's commonly known as the DELETE Act, and it updated California's data broker transparency law. Among other things, it moved the data broker registry from the Department of Justice to our agency, and it expanded some of the consumer protections in that law. There was a great deal of work by agency staff and by the Office of the Attorney General to move the registry, and I'm very pleased that the registry and thankful for all the work that the registry has resided with the agency already since January 1st. We saw a really impressive demonstration of the new registry earlier in the year. But in order to fully implement the law as directed by the legislature, we do need to promulgate some regulations. So Mr. Laird, our general counsel, and Ms. Liz Allen from the legal division will present on this item. I'd like to turn your attention to the materials for today, which include a short memo and the draft proposed regulations. Thank you both, Mr. Laird and Ms. Allen. Welcome, Ms. Allen, and please begin when you're ready.
Thank you, Chair Urban. I am going to largely defer to my colleague, Ms. Allen here, but I would be remiss on Public Service Appreciation Week to not acknowledge that Ms. Allen has been a tremendous asset to the effort to get the registry live, to help put together these draft regulations, and really all things DELETE Act. So kudos to Ms. Allen, and I'm going to let her go ahead and present this item to you.
I do want to thank you as well, Ms. Allen. I've really seen the public pick up the reporting from the data broker registry, the fact that it can be sorted by the kinds of information that's collected, I think has been really helpful to the public. I've seen a couple of articles about it in blog posts and so forth. So I really appreciate all of the work that everybody put in, and certainly you to really build this transparency for the public. So thank you.
Thank you. Thanks, Chairwoman Urban, and thank you, Phil. Yeah, my name is Liz Allen. I'm an attorney in the legal division and within the data broker unit. I'll be introducing this very short regulations package. So this package, of course, just addresses the data broker registry, which is one part of the 2023 law. The law, of course, contains 2 different parts. The data broker registry, which was administered by the Department of Justice from 2019 to 2023. And then we took it over this year, starting January 1st, 2024. The second part, of course, requires that the agency create an accessible deletion mechanism that allows consumers to instruct data brokers to delete their non-exempt personal information through a single request. That, of course, doesn't come into effect until January 1st, 2026. As a reminder to the public, this short package addresses only the data broker registry requirement and not the accessible deletion mechanism. We, of course, plan to update the board and the public on and preview kind of the steps that it takes to build such a system in state government, and to tell you about and report out about the outreach that we're doing on the technical side of that system at a later board meeting. And of course, we'll introduce a regulations package about the deletion mechanism at a later date. So real quick on just the registry piece, the data broker registration process launched within the agency for the first time in January of this year. We, through that effort, encountered a variety of common questions, occasional obstacles, and all of that indicated a need for clarification of SB 362's registration requirements. So a bit, of course, for as most of us know, but just as a reminder to the public, a business that meets the very specific definition of a data broker in the previous year must register annually with the agency by January 31st. It's important to note that the registry requirement is a retrospective requirement, meaning that data brokers are merely reporting to the agency about past actions that they took in the previous year. It is not about the current one. And this is a key piece of transparency for consumers because it tells them who has their data from the last year, so they can go and delete and make a deletion request about it. And this transparency is incredibly important for consumers because by definition, data brokers have no direct relationship with consumers. So consumers need to know that they exist and then need to know who has their personal information so they can then exercise their privacy rights. The full list of data brokers and the information that they've reported to the agency can be found on our website. And of course, the data broker that fails to register by January 31st may be liable for administrative fines and costs in an administrative action or investigation brought by the agency's enforcement division. So these proposed draft regs largely memorialize the agency's existing practices related to the registry. It also clarifies key terms and concepts, such as what does it mean for a data broker to have a quote unquote direct relationship with a consumer, what data qualifies as minor data, and reproductive healthcare data for reporting purposes. The remainder of the regulations clear up confusion pertaining to how and when a data broker can, for example, remove themselves from the registry or change information. It clarifies disclosure requirements and otherwise describes our current practices. These regulations will ensure a smooth registration period in January of 2025. So please let me know if there's any questions.
Thank you, Ms. Allen. Questions, comments from the board?
I had a question. I think I've got it in the right place here. Did I read correctly that you can only pay by credit card?
Well, so this year we only could accept checks. And so people were mailing us checks and then we had to process them. And we also accepted some wire transfers from international companies. And so we are onboarding a payment processor to ensure a much smoother, lower intensity tracking system for ourselves.
I might just add to that, Mr. Worth, that there was significant demand for the credit card option. And in fact, our understanding is generally businesses prefer to pay by credit card.
But we're saying they only can pay by credit card, right?
We're allowing for an exception through a process in the regulations if for some reason a credit card wasn't available.
Right.
That is the sort of standard default method.
Yeah.
Hopefully we get a break on the credit card fees as a state agency.
Actually, that's a great point. The regulation does incorporate that. In fact, that would be part of the registration they'd be paying. So the data broker will pay any sort of processing fee.
Yeah.
Thank you.
Yeah. Thank you, Mr. Worth. Mr. McTaggart?
I actually had underlined the same thing as Mr. Worth. And my only question was, does it make sense? I mean, I know what we're trying to do here and cut down, but how about debit cards or maybe like the Zells or is there any kind of notion that might make life easier for people as well? Just more electronic things than just, if you could have some kind of language like, or other similar thing that you guys get to decide in your wisdom, it might just make life easier for people out there.
I think we can certainly take the feedback to at least add sort of a debit option into this draft. The one thing I'll note that we're trying to kind of confront with all of this is prohibitions around underground rulemaking. So certain discretions are we have to be careful with, but identifying sort of the range and types of payments allowable should be fine. So we could absolutely take that feedback and incorporate it in the draft.
To that question, does it work for you to take this feedback and have 7600C and build that into your analysis of 7600C so that for example, the electronic payment mechanisms that Mr. McTaggart mentioned could be an EEG. I'm just trying to think of a way where we can, assuming that everyone is in agreement or that we have a majority in agreement, to move this forward so you don't have to bring a draft regulation back to us. And I think that this should fit within 7600C as is, or you could add EEG, check, money order, or another electronic funds method. If we could approve that today, I think that would be efficient for you. If you could just let us know what is the appropriate approach.
Yes, we can make any recommended changes to that language today, and that would be the language we'd go out with.
Okay, thank you. All right. Any further comments or questions from board members on this? All right. Thank you very much for all the thoughtful work on this and for taking the experience from January and hopefully making it as streamlined as possible for all of our data brokers who need to register and to build the transparency and privacy protection mechanisms for the public. I will request a public comment again to give a preview. I expect to propose a motion to direct staff to authorize to direct and authorize staff to advance this proposed data broker registration regulations, the ones that are in your materials for today, for formal rulemaking. And as a reminder, that would include commencement of the 45-day public comment period and to otherwise authorize staff to make additional changes where necessary to improve the clarity and to reflect the discussion today that we just had and to ensure compliance with the Administrative Procedures Act. So I'll say that a little bit more formally, but I first would like to take public comment.
This is for agenda item number 4 regarding SB 362. If you'd like to make a comment at this time, please raise your hand using the raised hand feature or by pressing *9 if you're joining us by phone. This is for agenda item number 4. I believe that there are a few hands raised. We have Jose Torres. I'm going to unmute you at this time. You'll have 3 minutes to make your comment, so please begin as soon as you're ready.
Good afternoon. Can everyone hear me?
Yes, we can. Thank you.
All right. Thank you. Good afternoon. Jose Torres Casillas on behalf of TechNet. On this proposal on data broker registry regulation, wanted to provide our public comment. So starting off, having to identify the individual product is much too specific without a corresponding consumer benefit. Providing individual product names could create long, unwieldy list of various products for each company. In short, for 7603 Section 2, we recommend removal of the word product while retaining language about a description of services covered by the enumerated state or federal law. In addition, the requirement around approximate proportion of data collected and sold as compared to total annual data collected and sold is too vague for uniform compliance without specifics on how to perform the calculation. Companies may choose to answer very differently, which would end up becoming very problematic. Within 7603 Section 3, we also recommend removal of the requirement or replacement with appropriate detail for the industry to understand how to calculate proportion in sales. Finally, in today's dynamic marketplace, consumers will often use services for a period of time, and then they may experiment and go elsewhere. to get similar or the same services, but then they might return. That's the benefit of a competitive marketplace. And indeed, consumers often want to stay informed about services and offers available from a number of different entities offering services. Therefore, we don't think there is sufficient basis to impose a time frame with regard to when a direct relationship ceases. In this case, does a business no longer have a direct relationship with a consumer by continuing to save their account credentials or their music playlist or even past orders that they may have placed on the website, which might be needed for a customer's tax purposes, for example? As such, within defining direct relationship in 7601, we request that you add the word interacting, but also remove within the preceding 3 years from the proposed definition of direct relationship. I thank you for your time and consideration.
Thank you. Next, we have Bailey Sanchez. You have 3 minutes. Go ahead and unmute yourself.
Hi, am I unmuted?
Yes, go ahead.
Okay, thank you. Thank you for the opportunity to speak. My name is Bailey Sanchez, and I'm a senior counsel with the Future of Privacy Forum. FPF is a think tank focused on consumer privacy and helping policymakers and other stakeholders find consensus on responsible business practices for emerging technology. My comments today focus on the draft regulations and in particular, the proposed definition of direct relationship. As currently drafted, the regulations would consider a data broker to include a business that sells personal information about a consumer that the business did not directly collect from the consumer, including instances where the business has a direct relationship with the consumer. We read this as an expansion of what would constitute a data broker under the DELETE Act, which is focused exclusively on businesses that lack a direct relationship with individuals. FPF provides comment today not to opine on the prudence of this policy decision, but rather to note that this may have consequences come time for the development of the accessible deletion mechanism that's also called for under the DELETE Act. The DELETE Act calls for an accessible deletion mechanism that requires a data broker as defined to, upon request, delete any personal information, not just information collected from third-party sources. If coupled with a broader definition of what is considered a data broker, this raises questions about how the accessible deletion mechanism could function in a way that aligns with reasonable consumer expectations. An individual taking advantage of this accessible deletion mechanism in this case, that it was to encompass organizations with whom they have a direct relationship with, could delete not just third-party data collected about consumers, such as clickstream data used for targeted ads, but also first-party data affirmatively provided to the business, potentially including entire accounts. An individual could inadvertently delete their entire social media profile, email account, or online file storage. We recognize that the agency is still developing that accessible deletion mechanism, and this is an issue that could perhaps be addressed through separate regulations at a later date. However, even at this stage, we encourage the agency to act intentionally to ensure that its approach under the DELETE Act both empowers consumers and is aligned with consumer expectations. Thank you for your time and consideration.
Thank you. Next, we have Matt Schwartz. You have 3 minutes. Go ahead and unmute yourself.
Good afternoon. My name is Matt Schwartz, and I'm a policy analyst at Consumer Reports. Thank you to the board for the opportunity to comment and to staff for all the hard work on these draft regulations. Consumer Reports was a strong supporter of SB 362, the DELETE Act, and supports the agency's efforts to create a strong set of requirements to implement the law. It's long past time for data brokers that have operated to date in a largely unregulated space, collecting and sharing consumers' personal information without their knowledge, to be more accountable to both consumers and the government about their practices. While we support sections 7602 to 7605 of the draft regulations, I'd like to focus my comments on section 7601, definitions. Staff proposes a definition of direct relationship that clarifies that a business is still a data broker if it has a direct relationship with the consumer in one way, but also sells personal information about the consumer it did not directly collect from them. We think it's critically important to conceptualize data brokers in this manner. Otherwise, we risk opening up an unacceptably large loophole that may prevent large data brokers from coverage, which would contradict the spirit of the law. For example, some data brokers like Xmode, who was recently the subject of FTC enforcement, do have consumer-facing apps that allow them to directly collect information from consumers that they can use to augment their already vast data holdings about consumers collected from various other sources. In many cases, consumers are unlikely to associate such first-party data collection with the underlying data broker, especially if the app is branded separately, as was the case with Xmode. The fact that a data broker has multiple ways of building data profiles about consumers should not spare them of the registration requirements and future deletion requirements under the Delete Act. Data brokers that operate in this manner should have to register with the state and share information about their practices, and consumers should be able to exercise their deletion rights over at least the information that the data broker has collected about them from third-party sources. Otherwise, we risk leaving companies out like Xmode, who bills itself as the second largest US location data company.
You have 30 seconds.
We appreciate the draft regulations seem to reflect this understanding, and we urge the board to retain the definition going forward. Thanks again for the opportunity to comment.
If there are any other members of the public who'd like to speak at this time, please go ahead and raise your hand using Zoom's raise hand feature or by pressing *6 if you're joining us by phone. Again, this is for agenda item number 4. Madam Chair, I'm not seeing any additional hands at this time.
Thank you, Ms. Marzion, and thank you to the members of the public for those very helpful comments. I saw staff taking notes, so thank you for that. I'd like to remind everyone that what we are considering is to authorize staff to make technical changes and in reflection of the board discussion today, and to put the package together for the 45-day comment. I would very much be grateful if members of the public who commented today, as well as, of course, many others, would be able to provide that kind of helpful, detailed feedback during the 45-day comment period. Are there further comments or questions from the board that have come up? Or all right. In that case, I request a motion to direct staff to advance the proposed data broker registration regulations in your materials for today to formal rulemaking, including commencement of the public comment period, and to authorize staff to make additional changes where necessary to reflect the board's discussion today, improve the text clarity, or otherwise ensure compliance with the Administrative Procedures Act. May I have such a motion?
So moved.
Thank you, Mr. Worth. May I have a second?
Second.
Thank you, Mr. McTaggart. I have a motion and a second. Ms. Marzion, could you please conduct the roll call vote?
Board Member Lay,
Aye.
Board Member Liebert,
Aye.
Board Member McTaggart,
Aye.
Board Member Ward,
Aye.
Chair Urban.
Aye.
I have 5 ayes and 0 nays.
Thank you, Ms. Marzian. We have the motion carries with a vote of 5-0. I want to thank Ms. Allen very much for the helpful presentation, again, for the public comments and the board discussion. And we will look forward to hearing public comment from the regulation in the formal rulemaking process. We will now turn to agenda item number 5. This is our one of 2 regularized discussions of regulations, proposals, and priorities. As a reminder, this is a time to give staff advice on resources and potential priorities for regulations and provide guidance for the upcoming year. That is likely next year. We can talk about it. We will have another update and discussion at the end of the year. This item will be presented by Mr. Laird and Ms. Lisa Kim, Senior Privacy Counsel and Advisor for the CPPA. Welcome, Ms. Kim. It's wonderful to see you as well. I'd like to draw everyone's attention to the materials for this item. There's a chart mapping the priorities from last year and where we are, I believe, if I interpret it correctly. Thank you. Please go ahead.
Thank you, Chair Urban. Once again, I'm going to first of all acknowledge the wonderful contributions Ms. Kim has had in a week of public service appreciation to this agency and to these regulations. And so I'm going to let her introduce this item.
Thank you. So item 5 is our biannual update on our rulemaking efforts and items proposed by individual board members. As a reminder, at our meeting last May, we provided the board with a color-coded chart that identified different rulemaking items. At that meeting, the board directed staff to commence rulemaking on the green and blue items and otherwise authorized staff to commence rulemaking on the other item in staff's discretion, taking into account resources and timing questions. The updated rulemaking topics document in your materials basically includes 2 tables. The first table are the items that are in progress, which have been incorporated or being incorporated into the proposed rulemaking package that staff is currently working on. And then the second table represents ideas that have been raised by individual board members, lawmakers, and the public on various occasions. If the board recalls, these were generally the items in the chart last year that were identified as requiring more time and resources by staff. The board has not expressly determined which topics staff should dedicate resources to analyze and or pursue when it has capacity to begin new projects. So given the agency's current workload, the board can choose to wait until its next biannual regulations discussion to begin assigning priority to the concepts on the chart or any new ideas that are introduced today. Or the board can begin providing such direction at the meeting today. If the board would like us to move forward with any of these items identified on the second chart or anything discussed today, we do ask that the board come to some type of consensus and provide us with some specific direction as to how we can move forward. That is basically my presentation in short here, but I'm very much open to taking any questions regarding any of the 2 charts or anything related to future rulemaking.
Thank you, Ms. Kim. Mr. Wirth.
Ms. Kim, I have a question. What would staff prefer? You asked we could wait to give you direction or give you some now. It's really a function of if you had direction today, can you even implement that direction with what else you already have on your plate?
Thank you for the question, Board Member Wirth. So yes, as you've heard, and as I think you're all aware, we're working on a pretty major package right now that incorporates a lot of components that was directed to be prepared for formal rulemaking at our last meeting. In addition, we've also now just received direction to go ahead and commence rulemaking for these registration regulations. And so understanding, we are a mighty but still somewhat small legal division working on all these regulations, continuing to prioritize the packages I just mentioned. We anticipate it would take us till later in the year to substantively turn to yet a new project. At the same time, we want to respect that this board sort of directs where we prioritize, and any direction or thought given from the board today, certainly in some ways, the earlier we hear about it, the more we can start thinking about it. I just wanted to be clear with the board about our capacity to really start in earnest on some of these projects and when we might be able to bring back more thought through proposals in response to any of that direction.
Thank you, Mr. Laird. Other comments or questions? Mr. McTaggart.
Thank you. It's good to see this back here. It's great to know where the regulations are a living, reading document that keep on getting better. I have a question on the updated the summary sheet. So we don't necessarily know the actual language. This is just the concepts, and then you'll sort of flesh that out. Okay, I just want to make sure.
These are basically ideas and concepts that have been identified by board members or other members of the public. Whatever proposal that we move on would require us to do some analysis and thinking through as to what would be the scope and what makes sense going forward. And then we would make a proposal to the board.
Okay. And so what would be most useful to you in terms of maybe this is for the chair, but what would be most useful to you in terms of how we're looking at this? Are we supposed to get, top 3 or something, or because I'm one day, at first I thought, oh, the first page is the stuff they're going to work on, and the second 2, and then I realized no, it's just they're all. So, or is the first page the one that's what you're working on mostly, and then the next 2 are?
Yes. So the first page, the first table is our stuff, our items that have already been incorporated into the future rulemaking package that we plan to move forward, the omnibus package. It's the second chart that we would request that the board give direction to the extent they want us to prioritize those items.
I think what you're hearing from us is we want to be useful, and we also we want to be helpful, and we also understand that you have a lot on your plate right now with the omnibus package that you've been working on. And so in my view, I think this list is great, and I would love to hear from board members anything that is in your mind that is not currently on the list. I think that would be helpful for staff to be able to jot down. But if it is the case that realistically, the packages, I guess, that you're working on, the omnibus and with the ADMT and all of the other things, is what you're going to be working on for the next few months. And it would make sense to revisit in our second biannual meeting. That sounds great to me. If there's anything that you think that we should move on more quickly, I think we would be glad to hear about that as well. But if you're saying that like that's really the situation with the resources, I think it would be helpful for us to know. I think that's what I'm hearing.
That's really the situation with our resources.
Okay. All right. I'm just going to be blunt about it in that case. And so I think that's realistic and helpful to know. And in my view, then I think that it would be fine for us to revisit this in our second biannual discussion. That's just my opinion. And if board members have anything to sort of add to the list for that next discussion, I would like to hear it. Mr. Lay, then Mr. Worth. Oh, sorry.
Yeah, that was my take as well. Is that if there isn't going to be capacity until likely the end of this year, maybe we could just push this item to a later board meeting this year, or at this time next year as well, and just see how capacity is at that point. Because it doesn't seem like there is capacity to really do this and prioritize the the ADMT package.
Thank you, Mr. Lay. Mr. McTaggart, and then Mr. Worth. Sorry. Mr. Worth.
I was just highlighting that he had his hand up. That's all. I'm in agreement as well.
Thank you, Mr. Worth. Mr. McTaggart.
Okay, Jared, this isn't exactly what you asked, but I would just say on the second page, personally, I feel like as a biggest state in the country, and I think the most robust privacy law, the one area that I still think we are weak on is employee data and employee and business to business data. And frankly, as I know why it was in there, I expected the legislature in its wisdom to do something about it. They did not by the deadlines. Now we have the situation, which I don't think is helpful, especially for business to business data, where you can have a disgruntled employee who really could throw a wrench in the works if they left in a business they've been in for 30 years, and then every email they'd ever sent was their personal information. They could make life difficult for for all the companies they've done business with, and then the employee data as well. I think, and I've said this many times, I think there's a compromised position in the middle where we're more rational than just saying employees are just consumers like anybody else. So that's where I would spend my time.
Thank you, Mr. McTaggart. Other comments or questions? Then I think we generally have consensus that we would leave to staff's discretion anything that you fit into the chinks of a time as you are working on the current packages that we've been talking about. And I assume that if something arises that's urgent, the general counsel will let me know to put on an agenda item out of order or out of the regularized calendar. So I thank everybody on the board for the comments, and I'll ask for comment from the public.
This is for agenda item number 5, regulations, proposals, and priorities. If you'd like to make a comment at this time, please raise your hand using the raise hand feature or by pressing *9 if you're joining us by phone. This is for agenda item number 5. Madam Chair, I'm not seeing any hands raised at this time.
Thank you very much, Ms. Marzian, and thank you very much, Ms. Kim. Really appreciate the helpful chart, and we'll look forward to the next conversation when it comes time. Thank you. With that, we will move to agenda item number 6, which is a public affairs campaign update from Megan White, our Deputy Director for Public and External Affairs. Welcome, Ms. White. I think I will just go ahead and turn it over to you because we heard some exciting ideas and plans in March, and I'm excited to hear the update.
Yes, thank you, Chair Urban. Appreciate members of the board. And I'm going to follow our general counsel's lead by thanking the amazing public affairs team for all their assistance with our paid media campaign. And just first, before I jump into the paid media campaign, I feel like I would not be doing my job as a Deputy Director of External Affairs if I didn't mention our stakeholder meetings one last time. So I appreciate Chair Urban for raising them at the beginning of this meeting. But just for members of the public who are joining us, a quick reminder that we are kicking off our stakeholder meetings next week. So we encourage the public to attend. These are to receive primary feedback on the agency's proposed regulations on automated decision-making, technology, risk assessment, and cybersecurity audits. Our first session is going to be Monday, May 13th. So that's this coming Monday in LA. Then we'll move to Fresno on Wednesday, May 15th. Both of those meetings are going to be in person from 3 to 7. For those individuals who can't join us in person, please join us for the Sacramento meeting. That's on Wednesday, May 22nd. That meeting is going to be hybrid, so you're welcome to join us in Sacramento with a Zoom link. And that meeting will be from 2 to 6. You can get more information by visiting cppa.ca.gov. It has all the info there. If you just click on our announcements tab, you'll see it's the very first announcement. And you'll also see a button where you can register if you'd like to register, but that is not essentially, you don't have to do it. It's completely optional. And the legal team will bring back a summary of those sessions at an upcoming board meeting. Back to the agenda item at hand. I appreciate the ability to plug that one last time. So for the media buy, since the May board meeting where I provided an overview of what we were thinking in terms of our media buy, we took all the great feedback that was provided by this board. In addition, we had separate conversations with board member Worth and McTaggart, as was directed by the larger board at that March board meeting, to get a little bit more information and direction for our media buy plan. Then we worked with our consultant Census to revise the media buy plan. And that's what you're going to be learning about today. Next slide, please. So you'll see here on this pie chart that we've broken up our paid media buy campaign to a couple different channels. The goal is to have the broadest reach possible to reach the numerous audiences throughout our very large state of California. It's very key to a successful statewide public outreach campaign to use various channels to be able to reach such a large audience. So you'll see here, if you look at this pie chart, you'll see that some channels like out of home, and that's something for those not familiar with that terminology, that's billboards and digital displays. We're going to use something like that to grab people's attention. In this pie chart, you'll see that makes up 21%. So that's a pretty large portion of our buy. But that's something that people will see very quickly as they're driving by, going 60, 70 miles an hour. So we're not just relying on something like that. We're also going to have something where we can do a deeper dive. There, we're looking to radio, streaming audio, and podcasts, and these will convey more detailed messages along the lines of the radio spot that you heard when I presented at the March board meeting. In addition to that, our goal is to really meet people where they are. For that, we realized that we needed to use page search, digital video, and paid social, since so many people are on social media nowadays. So we'll be integrating that into the buy plan as well. I would like to flag that we were very thoughtful with our paid advertising approach throughout the whole plan, but particularly when it came to items like paid search, digital video, and paid social. We had the utmost consideration for people's privacy rights. So as discussed, we'll limit these ads and gear the spend with that in mind. We're not doing behavioral advertising. We're making sure that there's complete compliance with the CCPA. But we also wanted to spread the campaign so we can reach people where they are. Moving on to the next slide. Okay, and all of these that I'm going to go through now, the radio, the print, and the community-based advertising, those were all also reflected in the pie chart that I just showed. But I wanted to do a deeper dive on this approach because this is really targeted to our diverse and traditionally marginalized groups. So when we were coming up with this paid media plan, we considered the diversity of our state. Not everybody speaks English here in California, and there's a lot of different cultures and languages that make our state so wonderful. So when we were doing our paid radio, when we were doing our radio ads, we created them in Spanish, and those will stream in terrestrial streaming platforms and podcasts. Moving on to print, we're going to do a statewide newspaper campaign. This will be in newspapers that you would receive as a hard copy, and then also those e-newsletters that a lot of us receive. That's how many of us get our newspapers nowadays on our inbox. So both of those are included when you hear newspaper and print. It's not really print anymore, only print anymore. But we're going to use this paid campaign to reach broad general audiences along with the more niche targeted audiences. So we're going to be advertising in everything from the LA Times to the Korean Times. We will be hitting more than 40 different ethnic papers and senior publications in addition. Our ads will be translated into at least 6 different languages based on the different newspapers that we will be advertising in. And the last one I really want to touch on is the community-based advertising. For this, we partnered with a vendor that has a grassroots approach, and that vendor to advertising. This vendor has worked on numerous state and federal public awareness campaigns, and they've been around since the 70s. So they have very strong partnerships. What we do with this team is we'll be in storefronts in communities. So people will be able to go into their local supermarket, pharmacy, ethnic grocery store, convenience store, laundromat, and they'll see our brochures. They'll also see maybe a poster sitting right behind the cashier or maybe a banner out in front of the store. So it's a great way to get the word out in a non-traditional grassroots way. And this is going to complement our grassroots campaign that we'll be launching later this year. I'm excited to share that we're about to add 2 more team members to help with the grassroots outreach campaign. And so the paid and the grassroots will complement one another. Moving on to slide 4. Okay, so this gives you a general timeline of not only the campaign, but also the various channels that we're going to be advertising. So as you can see, we are in May, and the campaign will begin this month and run for over a year. This chart shows each channel and when it will run during the course of the campaign. You'll also see on the far end, we've included the reach for each of these channels. Now, of course, these are estimates, but nonetheless, it gives you a feel for how broad and far-reaching this campaign is going to be. Some components are a little lower cost, but have high impact, and so they will run for the majority of the campaign. This includes things like digital displays, paid social, and paid search. Other components, go ahead.
I'm sorry to interrupt
Of
that
course.
slide, but I'm not a public affairs expert in any way.
Of course.
And I'm so curious, what is digital display?
That's a great question. So digital displays are going to be like when you're driving down the billboards and you see the displays changing as you go instead of the
like
staggered.
LED billboard.
You got it.
Okay,
Apologies.
thank
I should have been more clear. Yeah. So, and those have a lower cost. So this paid social, paid search. Other components that are more like the out of home advertising, those will run for 10 months out of the campaign. Things like print, streaming audio, podcasts, and radio will have shorter bursts throughout the campaign. We'll be bunching these efforts to maximize their impact, and they will satirize the market by having quick spurts. But we're also being mindful of our budget, so we're not going to be running some of these more expensive things throughout the course of the campaign. Moving on to slide 5. And I know I touched on this a little bit in March, but I just wanted to bring it back again. We developed numerous different ads for different channels to keep the campaign fresh. As we mentioned in March, we're targeting all Californians, but particularly those in the 30 to 60 demographic, because based on our survey, they're the least likely to know about their rights and exercise their rights. But one thing will remain consistent throughout all of our advertising, and that will be directing people to the privacy.ca.gov website so they can learn more. Because as you know, advertising is very short, the call to action is to learn more. So once again, I'd just like to praise Ms. Cameron, who designed all of these beautiful displays that you're seeing here. We're so lucky to have somebody so talented on our team. And in addition, Ms. Cameron has led the effort to develop privacy.ca.gov, and we will continue to add more information onto that website. We understand that, we launched it and there's a lot more information, videos to come. So please know that's top of mind for our team. That concludes my presentation. I'm happy to answer any questions that you have.
Thank you very much.
Thank you.
Questions or comments from board members? Mr. Worth?
That's okay. Thank you. Just a comment, as you mentioned, we had a subcommittee that kind of dug into this a little bit. And I think this is an incredibly comprehensive plan. I think one of the things we talked about is that look back and audit the different channels to see what worked better than what didn't, because I think the spend is real and I think the need is real. So we want to make sure it's as effective as possible. But I really appreciate the effort and the scope of the whole campaign. So thank you.
Thank you so much.
Thank you, Mr. Worth. Thank you, Mr. Worth. Mr. McTaggart.
Thanks. I just want to compliment staff on and especially Ms. White on a lot of work here that's gone into this, and including being willing to make changes that as we were kind of pushing to get this money spent. And I'm going to sound like a state bureaucrat here, but we do need to spend it in order not to lose it. And I'm glad that we are going to be able to get the word out, and it's going to be spent productively, which is educating Californians about their privacy rights. So I want to thank you all, and I'm looking forward to seeing some of these ads out there.
Thank you very much, Mr. McTaggart. I also want to express my thanks. It was very exciting. Your last presentation was very exciting. To see this sort of come to fruition is even more exciting. As you know, Ms. White, from before you were on board, the board has been very invested in the public awareness aspect of our duties and our responsibilities to Californians. And of course, we had a big regulations package to do, and we've had lots and lots of things to build. So to see a plan that takes off like a jet and goes, for an extended period of time is really, truly exciting. And I know it's an unbelievable amount of work. So I really appreciate the investment. I think we all do. And I really appreciate the investment of Mr. Worth and Mr. McTaggart for providing some additional sort of board feedback and information between the meetings. I also really want to express my support for the multi-channel approach and the multi-community approach. I was really pleased to hear that was part of the plan in March. And I think it was maybe Mr. Lombard in public comment had suggested making sure to reach out to channels. I think he mentioned the Black community in California, but other communities as well. And it seems like that's really coming to fruition. I think that's crucially important in our diverse state, and I really appreciate that. Really, really working to be sure that our message can reach as many Californians as possible. And I absolutely love these designs. I really love the Protect Your Privacy, We'll Give You a Hand. I think that's clever and delightful, and will really give people a quick way to see, what they can do, and to then come to privacy.ca.gov and do it. So thank you all so much for this effort.
Thank you. Thank you so much for your kind words and assistance.
Is there, Mr. Lay, I apologize. You're in the corner of my eye, but I just see you.
Yeah, no worries. Again, great work on this. And I just had two quick questions. One is, how much budget is left after this, this campaign runs? And the second is more of a comment on the privacy.ca.gov. I had visited it, and I just think the one thing that could help is like more examples of like, kind of like a thought, like kind of like in our regulations, there's like examples of how this thing can apply. I think that might help folks kind of understand their rights under the CCPA a little bit better. But I do love that locked acronym that you've all got going on there. So, yeah.
Thank you, Mr. Lake.
Yeah.
I use the locked acronym all the time to remember when people ask me what the rights are. It's a good mnemonic.
Completely agree. And I believe Miss Kim is the one who came up with that. So kudos to her. Yes. Thank you, Chair or Board Member Lay. I agree. We do need to add a lot of things to the privacy website. And I think examples are a wonderful way to do so and make it really tangible for people. In terms of the question that you had, this buy will complete the media buy for that contract. That's why it's going to run the 12 months. But as you may be aware, we do have an RFP out right now that includes a media buy portion. So that I can't speak more to that because it's currently out for public bid, but I'm happy to provide an update at some point once a bidder has been selected. But that will have a media buy component, assuming that it comes through a successful RFP.
Thank you, Ms. White. With that, I'll ask if there's public comment.
This is for agenda item number 6, public affairs campaign update. If you'd like to make a comment at this time, please raise your hand using the raised hand feature or by pressing *9 if you're joining us by phone. This is for agenda item number 6, public affairs campaign update. Madam Chair, I'm not seeing any hands raised at this time.
Thank you very much. And thank you again, Ms. White, and to everyone who's been working on this really impressive campaign. And I will look forward to seeing how well it's reaching Californians and how helpful it is to them as we go through it. With that, let's move to agenda item number 7. Agenda item number 7, I previewed at the top of the meeting. This is our agenda item today for public comment on items that are not on the agenda. Board members must stick to the items on the agenda, but Bagley-Keene allows us to provide this item for public comment on items not on the agenda. So we welcome public comments today. Before we proceed, I just would remind everyone again that the only action the board can take is to listen to your comments and consider whether we might discuss the topic at a future meeting. No other action can be taken on any item at this meeting. I know it can seem at times as though board members are not being responsive, but following these rules is crucial to ensuring that the Bagley-Keene Open Meeting Act is followed and to avoid compromising either complementers, goals, or the board's mission. With that, is there any public comment?
This is for agenda item number 7, public comment on items not on the agenda. If you'd like to make a comment at this time, please raise your hand using the raised hand feature or by pressing *9 if you're joining us by phone. Again, this is for agenda item number 7, public comment on items not on the agenda. Madam Chair, I'm not seeing any hands raised at this time. Does anyone in the room have any comments?
Thank you, Ms. Marzian, and thanks again to the public for attending to our meeting. With that, I'll move to agenda item number 8, which is our item for future agenda items. At this time, first the board and then the public will have the opportunity to suggest agenda items for a future meeting. As a reminder, we can only discuss whether to place those items on a future agenda. We can't discuss them in substance. Let me first go through my running list of items that I've gathered so that everyone is aware of what might be upcoming on our regularized agenda and so forth. So we will have reports out on public awareness, and eventually I think we're going to hear about public awareness budget a little bit as you get further into it. So thank you in advance for that. Ms. De La Torre and I were the rulemaking process subcommittee. As I mentioned at the end of last meeting with Ms. De La Torre's departure, I have no subcommittee partner. But when we have time in an agenda on an agenda, I will report back to some of our findings and we can discuss that and how we want to think about rulemaking work process going forward. We do have our board handbook outstanding. We've welcomed another new member. So again, when it is appropriate, with staff recommendations based on board individual feedback they've received, that will come back. I still have Mr. McTaggart, your request of rulemaking to include partial deletion for the delete, right? But I think that was on the chart. So I need to update my list of ongoing items, but please correct me if I'm wrong. For our regularized calendar for July, we will expect to hear from the budget plan for the upcoming BCP process. It's the same as last year. As a reminder, it allows us to be briefed and give some immediate feedback following the passage of the budget by the legislature in July. We will expect to hear our annual hiring update, which includes diversity and inclusion metrics, and that's up from September in last year because CalHR's reporting calendar makes it better to do that in July. And then previewing September, we have a number of rulemaking pieces in the works. And so we will, I assume, hear updates about those pretty soon. I can go through the rest of the calendar if you'd like, but it's also on the website. And I will ask if there are other items board members would like to bring to my attention for future board meetings. Yes, Mr. McTaggart.
This has come up in the past, and it's obviously not going to happen right away. But I'd love a update on adequacy and
adequacy under the
GDPR, yeah.
GDPR.
Yeah, and whether I know that there are certain areas where we're we have certain differences and everything, but we have a international expert sitting in our midst right here who knows all those people over in Europe, and I'm sure he can tell us what his sense is, and he's been over there and he's talked to them all, and I'd love to get a sense from his point of view of how big a stretch is it to apply right now? Is there any fatal flaws, or could we actually push along and try to get something like that done? So I'd love to have a little update from him on that at some point in the future.
Wonderful. Thank you, Mr. McTaggart. Mr. Worth.
Yeah, one thing on the data broker registry that I think the public comment period starts for 45 days. I'd just like to see once completed how we reached out to the industry and what kind of feedback we got during the process. And frankly, for any of these public comment periods, I think it's a good exercise. Thanks.
Thank you, Mr. Worth. And as you go through a formal rulemaking process with us, we will receive all of the materials, all of the comments that we get, and staff will also digest them for us. So we will all look forward to that. And I think staff will, of course, let us know how they've responded to public comment. Thank you. Anything else from board members? All right. If there is anything that comes up between meetings, please bring please bring Mr. Laird's attention to them so that we can work to get things on the agenda. Are there any agenda items requested by the public?
This is for agenda item number 8, future agenda items. If you'd like to make a comment at this time, please raise your hand using the raise hand feature or by pressing *9 if you're joining us by phone. Again, this is for agenda item number 8, future agenda items. Madam Chair, I'm not seeing any hands raised at this time.
Thank you very much, Ms. Marzione. Thanks, everyone, for a very productive meeting. With that, I will move to agenda item number 10, because we've already held our closed session, which was agenda item number 9. Agenda item number 10 is our final item, adjournment. I'd like to thank everybody, board members, staff, and members of the public for their contributions to the meeting and to the board's work. I'd like to very much thank CPUC staff for your work to host us today. And I would like to thank everybody for their incredible patience with the vagaries of technology as we got the meeting started today. And for those of you who got everything to work so that we could have such a productive public meeting, thank you you very much for your efforts there. With that, may I have a motion to adjourn the meeting?
Comment.
Mr. Liebert,
This is
please.
a
please go ahead.
motion with a thank you to the great staff. You all did a fabulous job getting me onboarded here, and I wanted to appreciate all of you for that. So thank you, and I move to adjourn.
Thank you, Mr. Liebert. May I have a second?
Second.
Thank you, Mr. Worth. I have a motion and a second to adjourn the meeting. Ms. Marzion, could you please conduct the vote?
Yes, the motion is to adjourn. Board Member Lay,
Aye.
Board Member Liebert,
Aye.
Board Member McTaggart, Board Member Worth,
Aye.
Chair Urban.
Aye.
Madam Chair, you have 5 ayes.
Thank you very much. A vote of 5-0, and this meeting of the California Privacy Protection Agency Board hereby stands adjourned. Thank you, everybody.